All right, the meeting is being recorded. So we're going to start off today by going over quiz two's questions, so that I can make sure that you understand why certain answers were correct versus others. If we have time today, then we're going to go back over foreclosures and priorities. Mortgage priorities, because I think there's some confusion there. I'm going to see if we can clear it up. Okay, so let's get started. Question number one. I should say Prince. Prince, Michael, and Janet owned a large tract of land, Purple Acre, in fee simple as joint tenants with rights of survivorship. While Michael was on an extended international performing tour, Prince conveyed his interest in Purple Acre to Apollonia, who immediately reconveyed the interest back to Prince. Michael has an unfortunate and fatal accident with some pyrotechnics. His will devised his ownership in Purple Acre to his son Blanket, who owns Purple Acre. The answer is B. Prince and Janet in fee simple as tenants in common. Here's why. So it's a good idea to quickly diagram out the interests. So first you have Prince, Michael, and Janet, and they own the large tract of land, and they own it as joint tenants, right, with the rights of survivorship. Then Prince conveys his interest to Apollonia, who conveys it back to Prince, right? So here, immediately, as soon as there's this conveyance here, then the four unities that you need for joint tenancy have been severed. And so this interest becomes a tenancy in common. And so Apollonia can only give Prince a tenancy in common back. Okay. Nothing has happened to these two interests, however, over here. So Mike and Janet still have the joint tenancy with one another, and they have a tenancy in common with Prince. All right. So then Michael has a fatal accident. And so he wants to give his ownership to Blanket. We know that because this is a joint tenancy, as soon as Michael dies, his interest automatically goes to Janet. Right? So Janet now owns both Michael's interest and her interest. And because, again, she doesn't have a unity of title with Prince, then her interest is a tenancy in common. Okay, so that's why the answer is B. Questions on that? All right, seeing none, we're going to move on. Question number 2. The following events took place in a state that does not recognize the common law marriage. The state recognizes same-sex marriages and tenancy by entirety. Brady Smith and Jelly Jolie, who were never formally married, lived together over a 7-year period. During this time, the Jelly identified herself as Mrs. Smith with the knowledge and consent of the Brady. Brady and Jelly maintained several charge accounts as retail stores as Mr. and Mrs. Smith. Within this period, the Brady decided to buy a home. The deed was in proper form and identified the grantees as Mr. and Mrs. Smith, his wife, and their heirs, and assigns forever as tenants by entirety. Brady and Jelly were both independently wealthy. They both used from their proceeds of their last movies and paid for the house equally in cash. Later, Jelly realizes that her and Brady are not meant for each other and wants to know what her interests are in the house if she leaves him. What would you advise her? Well, we know that they don't own the house as tenants in entirety because one of the requirements for a tenancy by entirety is that there is a lawful marriage, and they don't have a lawful marriage. Well, what about tenants with the joint rights of survivorship? Well, that's not the default. Tenants in common is the default. And here the language doesn't specifically say that they are joint tenants with right of survivorship. So the answer is C, that Brady and Shelley own the house as tenants in common. Questions on number 2? Seeing none, moving on. Question number 3. Nina owned a 4-unit apartment building and lived in one of the units. There had been a string of burglaries in the neighborhood, and Nina was concerned for her safety. She figured if she could find some burly men to rent her a vacant apartment, she could scare away the burglars. So Nina posted on Facebook in a neighborhood group the following: 1-bedroom apartment, $600, man preferred. Based upon these facts, which of the following statement is true? The answer is D. Under the Fair Housing Act, Nina was not permitted to state a sex preference in the advertisement. So you might wonder why this doesn't fall under the exception of an owner-occupied dwelling with the FHA. Well, the prohibition on advertising the exception does not apply to the prohibition on advertising. So answer A is incorrect because, like I said, the the exclusion for owner-occupied buildings don't apply when we're dealing with advertising. Her motives don't matter, right? We don't have to find actual discriminatory intent, because if we needed to do that, it would be very difficult to prove any of these claims. And so the answer is D. Questions? Correct. It's only advertisement that the exceptions don't apply to. Remember, there are multiple provisions of the FHA, and specifically the owner-occupied building with no more than 4 living units is exempted from the remaining sections of the FHA, but not the subsection that deals with advertisement. All right, problem number 4. Khalid leased commercial space D to Tania for a term of 5 years with a start date of January 1st, 1990. On January 1st, 1990, Tania rented a moving truck, packed up her shop items, and pulled up to a commercial space D with the intent of setting up her shop. To her dismay, Tania found the previous tenant, David, was still there, ushering in customers and conducting business as normal. Tania, oops, that's correct. Tania brought an action against Khalid for a breach of lease. If Khalid prevails in the action, it is because C, the jurisdiction applies the American rule, and Khalid delivered to Tania the legal right of possession. Remember, the American rule only requires the landlord develop the legal title. The English rule requires that the landlord deliver both title and possession. So, this may be the question that just implies English wrong. Tania is responsible for filing an action to evict Ronald. So D is not correct because the English rule would have required Khalid to deliver title and possession. So Tania would not be required to file an action, and Khalid would have lost. So that's why D is wrong. A is wrong because that Donald's right to possess is not relevant. whether or not Donald has the actual right to possess, well, it's relevant because if he did have the right to possess, then Khalid um, could not have delivered legal title either, right? But that wouldn't just hold Khalid doubly liable, so he wouldn't win because of that. Let's see. Again, same thing. B does not bear on Khalid's duties. Donald's duties would not affect, would not allow Khalid to prevail because even if Donald had the right to possess and the right to title, that would mean that Khalid breached the right to the delivery of the legal title, right? So there's two. So yes, I can clarify. So the American rule requires, so there's two, when we talk about delivery, we say there's delivery of title and delivery of possession, okay? And so the American rule says that a landlord only needs to deliver legal title, meaning that the landlord properly delivered title to the tenant. So how could a landlord have breached that? Well, they could have breached it by not having, so the landlord could have, let's say, delivered legal title to tenant A and tenant B, in which case they would have not met the requirements for delivery of title, right? Because you can't give two entities the same interest in the land, like two different people the same interest in the land. So that would be a violation of title. So as long as, for the American rule, as long as the landlord delivers the title, which is a lease, to the party, the tenant, then they can wash their hands and they're done. They have fulfilled their obligation to deliver. Now, if we're talking about the English rule, then title and possession needs to be delivered. So it's not enough that the landlord gives proper title to the new tenant. The landlord has to make sure that the new tenant can take possession of the property, that there are no holdover tenants. So really, the difference between the two practically has to do with holdover tenants, right? And the American rule says it is the new tenant's job, as long as the landlord delivers proper legal title, the tenant, the new tenant, can evict these holdover tenants. They can go to court, and it is their job to do that. The English rule says now the landlord can't just deliver legal title. The landlord also has to make sure that there are no holdover tenants, and the landlord has the duty to evict any holdover tenants. Does that clarify the difference between the two? All right, great. So Buffy decides to venture out on her own, and so she moves into an apartment building owned by Faith. Because Buffy and Faith were friends, they didn't see any need to draft up a contract. Buffy paid Faith $650 a month for the apartments. The apartment needs some repairs. The toilet overflows, the faucets are all leaky, but Faith is too busy to be bothered. Buffy notices that the other tenants in the building are also having a hard time getting Faith to respond to their repair. One of Buffy's neighbors has been without hot water for weeks. So Buffy confronts Faith, demanding that she makes repairs for everyone in the apartment building by the end of the following month. The next day, when Buffy went to pay her rent for the next month, Faith told her that she was going to raise Buffy's rent to $9.50. Buffy pointed out that everyone else in the apartment building paid $6.50. Faith then gave Buffy the required statutory notice that tenancy was being terminated at the end of the month. By an appropriate proceeding, Buffy contests Faith's right to terminate. If Buffy succeeds, it will be most likely because, and the correct answer is B. The doctrine prohibiting retaliatory eviction states that the landlord can't evict residential tenants as retaliation for the tenant's reporting of a housing code violation, right? So they can't evict and the landlord can't retaliate based on any breaches of warranty of habitability. So question A is incorrect. Sorry, answer A is incorrect because if there's a periodic tenancy that was created, Faith may have actually given adequate notice, right? So, and the fact pattern says that Faith gave Buffy this required statutory notice. So that's A is not correct. C is not correct because there is no implication of the Fair Housing Act here. And then answer D is incorrect because absence to an express agreement otherwise a month-to-month tenancy can be terminated a periodic tenancy can be terminated at any time. And the fact pattern said that the required statutory notice was given. So you know that there's no issue here, and there's no such thing as a minimum lease term. Right, most jurisdictions don't have a minimum lease term. Even if there is a minimum lease term, there was no written contract here. So, okay. Next question. Joey leased her home, Creek Manor, to Dawson for a term of 3 years, ending December 31st of last year at the rent of $1,000 per month. The written lease provided that the tenant could sublet and assign. Dawson lived in Creek Manor for 1 year and paid the rent on time. After 1 year, Dawson leased Creek Manor to his friend for 1 year at a rent of $1,000 per month. The friend took possession of Creek Manor and lived there for 6 months, but because of their unemployment, paid no rent. After 6 months, on June 30th, the friend abandoned Creek Manor, which remained vacant for the balance of that year. Dawson again took possession of Creek Manor at the beginning of the third and final year of the term, but paid Joey no rent. At the end of the lease term, Joey brought an appropriate action against both Dawson and the friend to recover $24,000, the unpaid rent. In such action, Joey is entitled to, and the answer is A, against Dawson individually for $24,000 and no judgment against the friend. And the reason is because it's a sublease and not an assignment. So here we said, and how do we know it's a sublease? Well, Joey leased to Dawson for 3 years. And so this is the privity of contract and the privity of estate, right? And Dawson then then leased to the friend, but it was only for 1 year. So you know that it was going back to Dawson. And so that's why we know it is a sublease here. So because we have a sublease, Joey has no privity of contract with the friend, right? There's nothing here. The only privity of contract that exists is with, um, with Dawson. So Joey can only sue Dawson individually for the $24,000. Now, Dawson can sue the friend because the friend breached the contract that the friend had with Dawson. But Joey can only sue Dawson. Any questions on that? And we should do a game where you all guess which shows I patterned each one of these on. So anybody know which show that TV show that was? Yep, Dawson's Creek. Yeah, it wasn't very hard. Oh gosh. And I'm sure you all, I hope you all know the previous one. Question number 5. Yep. Megan's on a roll. Okay. Let's see. Did I do any other two? No, others were just fun pop culture stuff. Okay. Here's another TV-based question. Betty built a house in Riverdale called Riverdale Manor. After the house was built, Betty sold Riverdale Manor to Archie. He then sold Riverdale Manor to Veronica. Veronica had inspected Riverdale Manor prior to the purchase and discovered no defects. After moving in, Veronica noticed that when she took a bath, all the toilets in the house overflowed, to the point that they flooded the floors in all of the bathrooms. Veronica asked Archie about the defect, and he said that he did nothing to conceal the defect from her. Archie said he didn't think it was a big deal. Veronica hired a plumber who fixed the problem. She then brought an appropriate action against Archie to recover the cost of repair. If Veronica wins, it will be because, and the answer is A, the court applied the majority rule and found that Archie failed to disclose a known defect that materially affects the value of the property. Right? It's not B because the common law rule is buyer beware, right? Wouldn't require the seller to disclose anything. The situation may cause a health hazard, but that isn't a cause of action under the law, right? And here, with these multiple choice, you're always going to pick the best answer. D, Archie breached the implied warranty of habitability and fitness for purpose. The applied warranty of habitability only applies when you're dealing with leases, not when you're dealing with property sales. So that's wrong. And that TV show is? Come on, y'all. A little participation going here, Riverdale. Yeah, it was pretty easy. Okay, next one's a little bit harder TV show wise. Cole leased a building to Piper for a 10-year term for her new restaurant. Piper was too busy fighting off evil, so 2 years after the term began, Piper subleased the building to Leo for a 5-year term. Under the term of the sublease, Leo agreed to make monthly rent payments to Piper. Although Leo made timely rent payments to Piper, Piper did not send the payments to Cole. When Cole tried to find Piper, he could not locate her and learned that she had relocated to another state. Cole sued Leo for the unpaid rent. There is no applicable statute. Okay, so let's go ahead and diagram that out. We have here a sublease, which is stated in the question, but also you're going to want to make sure that you make sure it's a sublease, right? Because courts have held that it doesn't matter the language used by the parties, right? What matters is the actual relationship. So let's double check to make sure this is actually a sublease. So we have Cole that leads to Piper. So they're going to have privity of estate, privity of title. And then Piper subleases, and we know it's a sublease because the original lease term was for 10 years and Leo only got it for 5 years, right? So Leo made monthly payments, but Piper did not send them to Cole, right? So if the court finds that Cole is not liable to Leo, That's going to be because there is no privity of contract here or privity of estate, right? So a sublessee, so the answer is C. L is not in privity of estate or privity of contract with Cole. So A is wrong because a sublessee is not responsible to the landlord. They're only responsible to the tenant here. There is no novation here. And Leo's payment to Piper didn't discharge Leo's obligation to pay rent to Cole because Leo never had an obligation to pay rent to Cole. So that was a little bit tricky there. Questions on that? And anybody know which TV show that was? Charmed. Yep. All right. This next one is a movie, which I suspect many of you know. Gandalf held title to Lord's Castle for 25 years, but never lived in that castle. So Bilbo acquired possession of the castle under adverse possession law of the jurisdiction. When you have tricky chains of title, sometimes it helps to just write them out. So we know Gandalf had the property and then it went to Bilbo, right? 5 years ago, when Bilbo was off locating a ring, Samwise took over possession of the castle. Samwise repaired the drafty castle, put up no trespassing signs, and built a moat to enhance security. So here we have Samwise, but we're kind of unsure as to what this is, right? We know that there's 5 years. Anyway, when Bilbo returned, he found Samwise in possession of the castle. But before he had time to order Samwise to vacate the castle, Bilbo was called away on another epic journey. While Bilbo was on his journey, he crossed paths with Gandalf. And he orally told Gandalf that he was wrong to take the castle away from him and that he waived any claim he had to the land. Gandalf thanked him and said he would accept the return of the castle. Last month, unsure of the effect of his conversation with Gandalf, Bilbo executed a deed purporting to convey the castle to Frodo. Frodo promptly recorded the deed. So here we have a recording. Okay. The period of time to acquire title by adverse possession in this jurisdiction is 10 years. Who now owns the farm? Oops, that's the castle. My bad for the typo, y'all. I'm sure you figured it out, though. Okay, Gandalf, the answer is C, Frodo, because he took Bilbo's adverse possession title by conveyance. Why was this oral reclaiming or waiver? Why did that not give Gandalf property rights? Well, because it was oral. It did not comport with the statute of frauds. Remember, any transfer of property needs to be in writing, and that was not in writing. So it's unclear. So B is not correct because the neighbor, well, B is not correct because the answer doesn't make sense because I forgot to remove neighbor, but also because, so that should have been a dead giveaway. But aside from that, Bilbo's adverse possession, he already acquired it by adverse possession. He already acquired title. And so if Sam is trying to tack on, he needs to fulfill the statutory period, which unclear whether he did, but we did say 5 years ago, so that would not be the right answer. Bilbo, because he must bring quiet title to establish the farm. No. So you don't have to bring, there was a lot of typo in this exam. Sorry about that. So Bilbo did not have to bring a quiet title action to establish his title because as far as adverse possession goes, the title shifts even if there is not a quiet title claim. A quiet title claim A quiet title claim is, what was I going to say? Oh, quiet title claim is just used to prove adverse possession ownership, but it does not create adverse possession ownership. Yeah, I'm sorry, Megan, about the farm usage. I actually credited you all 1 point. There were 32 questions on the exam, and I actually made the bottom 31. And the reason I did that was to omit one of the questions in case there were some typos or anything like that. So I'll keep going, but honestly, that could be the number 9 could be the question that was omitted. Yeah, I always try to do that because there's usually a typo the first time I give. Even though I did read these over, I don't know how I didn't catch any of this. Okay, Madeline, and I had other people read it over, which is the really funny part. Okay, so I had other people proofread it, and nobody caught this. So number 10 goes to show you. Number 10, Madeline contracted to sell Monterey Beach house to Renata. The written contract required Madeline to provide evidence of marketable title of record, specify a closing date, state that time is of the essence, and provide that at closing, Madeline would convey by warranty deed. Renata paid Madeline $5,000 earnest money toward the $55,000 purchase price. The title report showed that an undivided 1/8 interest in Monterey Beach House was owned by another owner. Renata immediately objected to the title and said she would not close on Madeline's title. Madeline responded accurately that the other owner was her daughter, Abigail, who would be volunteering with Amnesty International in Africa until 2 weeks after the specified closing date. Madeline said that Abigail would gladly deed her interest upon her return, and that meanwhile, Madeline's deed warranting title to all of Monterey Beach House would fully protect Renata. Madeline duly tendered her deed, but Renata refused to close. Madeline sued for specific performance, tendering a deed from herself and her daughter, who had then returned. The court will hold for, the answer is C, Renata, because Madeline's title was not marketable and time was of the essence. All right, so A is incorrect because the title needs to be marketable at closing. And so this whole idea that it can be done within a reasonable amount of time, that is not acceptable. It has to be done at closing. Again, the same thing for B, the warranty deed would not give adequate interim protection. It needs to have been done before closing, because at closing, Madeline would have not delivered marketable title. And sure, Renata searched the title records and discovered the daughter's interest, but that's not why the court would hold for Renata. The court would hold for her because the title was not marketable, and the agreement was that marketable title would be delivered. All right. Number 11. Maria, a Hispanic female with good credit history and sufficient assets, applied to rent a house from Professor X. Professor X refused to rent to her and refused to give her a reason as to why he was rejecting her application. The house is still vacant. Maria files an action under the Civil Rights Act of 1866 for discrimination. Who will likely win and why? The answer is A, Maria, unless Professor X can prove that he had a legitimate non-discriminatory reason for his refusal. So B is also correct, but A is the better answer, right? Because the reason why, so Maria does establish a prima facie case for discrimination because her credit history is good, the apartment is still vacant, he refused to give a reason. This was patterned off the facts of one of the hypotheticals in your book. But why she would win was not only once somebody establishes the prima facie case, the burden then goes to the defendant, right? And if the defendant can't prove they had a legitimate non-discriminatory reason for the refusal, then summary judgment is found for the plaintiff. All right. Okay, Shay discovers that her sewage line is backed up, causing noxious odors and overflowing toilets. Ian, her landlord, keeps reassuring Shay that she will fix the issue, but blames delays in fixing the defect on his forgetful plumber. Ian has indeed called the plumber twice to remind him to service Shay's property. After about a week, Shay decides that she will withhold rent until Ian fixes the problem. Ian tells Shay that she cannot withhold rent because Ian is doing his best to fix the problem. Shay has asked for legal advice. Assume that Shay is in a jurisdiction that permits tenants to withhold rent as a remedy. How would you advise her? Well, the correct answer is C. Shay can withhold rent and stay in the house until Ian fixes the problem, because this is under the doctrine of the implied warranty of habitability. It doesn't matter that Ian feels like he made reasonable efforts, because had Ian chosen a different plumber, there's nothing in the fact problem to state that the issue couldn't be fixed, right? This is a matter of the landlord preferring a certain plumber and the plumber not delivering or not being able to fix the problem. And so C is the correct answer. B is not the correct answer because we're not talking, she doesn't need to vacate the premises because this is not a constructive eviction. She can just sue under implied warranty of habitability. And remember, the difference between constructive eviction and implied warranty of habitability is that constructive eviction requires that the tenant leave the property, right? Whereas the implied warranty of habitability does not have that same requirement. The tenant can stay in the apartment and raise the defense. Questions? All right, so yeah, that question was testing whether you knew the difference between constructive eviction and implied warranty. Okay, number 13, Captain Kirk executed a deed to convey his land to his friend Spock. Captain Kirk handed the instrument to Spock, saying, "This is yours, but please do not record it until after I am dead. Otherwise, the crew will suspect me of favoritism." 3 days later, Captain Kirk asked Spock to return the deed to him because he had decided that he would devise the land to Spock by will rather than by deed. Spock said that he would destroy the deed, and a day or so later falsely told Captain Kirk that the deed had been destroyed. 3 months ago, Captain Kirk, who had never executed a will, died. His son was his sole heir. The day after Captain Kirk's death, Spock recorded the deed from him. As soon as Captain Kirk's son discovered this recording and Spock's claim to the land, he brought an appropriate action against Spock to quiet title to the land. For whom should the court hold? The answer is C, because the deed was delivered to him. So this question is about the elements for delivery, right? So the son, so if we look at A, right? The son, because the transfer of the deed to Spock was a testamentary transfer, but it wasn't a testamentary transfer, right? You look at the intent of Captain Kirk, and Captain Kirk intended for the delivery to be at the time he gave the deed to Spock. He just didn't want it recorded so everybody didn't find out about it. Right? So under those facts, the delivery is completed, the delivery is, the elements of delivery have been met as soon as Captain Kirk hands Spock the deed. Now, about Captain Kirk asking for him to return the deed back to him. Well, once a property interest has been conveyed, well, good question, Jacob. So Jacob is asking, do we look to the intent at the specific time of delivery? Yes. So what you do is when you get a problem like this, you again start with diagramming out and you say Captain Kirk conveyed land to his friend and he handed the instrument to Spock. Okay. Whenever you have details about a document being handed over and it's a property question, your mind should immediately go to, is this proper delivery? Okay. So here for it to be a proper conveyance, we need to have delivery and acceptance. For delivery, we look at the intent of Captain Kirk. Because the document was physically handed over, we now need to make sure that this conveyance was proper. We need to figure out if this conveyance was proper. And to do that, we would ask, did Captain Kirk intend to divest himself of his property interest at that point in time, at the time that he handed Spock the deed? And the answer is yes, because he used words, this is yours, right? So at this point, Spock owns the property. Now, the deed's not recorded, right? So he may not have protections of recording, but Spock does own the property. We have a proper conveyance. So then 3 days later, Captain Kirk asks Spock to return the deed to him. Well, once land is conveyed, whether or not Spock wants to convey it back at this point is, Jacob says he got this one right, but he felt uncomfortable with his answer with all the lying and stuff going on with Spock. Yes. And I felt very wrong because I felt like Spock's character wouldn't lie because, his type of character was just bad at lying. But anyway, deceit. So basically, Spock here, the choice whether or not to return to Captain Kirk, the deed back to Captain Kirk, right? And he didn't do that, right? He said, well, I'll just destroy it. But it was up to him as to whether or not he wanted to destroy it because it is his property. At this point, right here, the conveyance was proper. So then we have, this his son trying to claim the property, right? But you'll notice, first of all, that the will it doesn't say that there was a will that bequeathed the property to the son. It's just that the son is his sole heir, and the sole heir in intestacy gets to claim the property of Captain Kirk. So that's how he was doing it. So, as soon as Spock got the conveyance up here, right, because then Captain Kirk dies, and then we have a recording somewhere here from Spock. It is actually here that the property interest is officially Spock's. The only time we really, you might be thinking, you might have got thrown off by the recording, Spock, because the deed was recorded to him. So it is true that recording would make his interest a priority interest. The delivery came first and the ownership came first here. So it really was because the deed was delivered to him. So I'm just reading through my, making sure I didn't miss anything. What else can I tell you? Request. Yeah, so essentially the subsequent recording of the deed has no effect on his claim of ownership. The claim of ownership is up here, and claim ownership at this point in time. Uh, the recording just provides notice, right? So we need to separate out from when there is actual ownership versus when there is notice. All right, that one was a tricky question. I had to throw some tricky ones in there, so that one was one of the tricky questions. Okay, a couple more. Daenerys conveyed Thorn Anchor by quitclaim deed as a gift to Arya before Arya went on, I was supposed to say, a journey to the wall. Gosh, how did nobody catch any of these typos? This is funny. Daenerys conveyed Thorn Anchor by quitclaim as a gift to Arya before Arya went on a journey to the wall. So Daenerys to Arya. Arya did not record the deed before she left. Daenerys, knowing that Arya would be gone for a while, decided to stay in Thornacre. 3 months later, when Daenerys was still in possession, she conveyed the land by quitclaim deed as a gift to Cersei, who knew nothing of the deed to Arya. Cersei did not record her deed. Daenerys then left Thornacre for Dragon Country. The realm that Thornacre is in has a race notice law. Yesterday, Arya learned about the deed to Cersei and that Cersei was living in Thornacre, so Arya immediately recorded her deed. And recorded her deed and sued Cersei for possession to quiet title. Cersei then recorded her deed and raised all available defenses. For whom is the court likely to decide? Well, the answer is A for Arya because she was first in time and Cersei was not a purchaser. Had Cersei have been a purchaser, she could have argued that she took as a subsequent bona fide purchaser, and then the answer would have been different. But because this was a gift, right, she conveyed the land as a gift, that means Cersei did not qualify for the bona fide protection. Questions on that? That was a Game of Thrones one, if anybody was. And the one before that was Star Trek. Those were kind of gimmies. Okay. Number 15, Stefan Salvatore owned Creepy Mansion. His brother Damon Salvatore lived with him and always referred to Creepy Mansion as my property. Needing some cash to finance a venture, Damon executed and delivered a warranty deed which purported to convey Creepy Mansion to Caroline in fee simple, reserving a 3-year estate for the Salvatore brothers. Caroline properly recorded the deed, then Stefan died and left Creepy Mansion to Damon. A month after the will was duly probated, Damon sold Creepy Mansion to Bonnie. He executed and delivered a valid warranty deed to her, and she paid valuable consideration. Bonnie promptly and properly recorded the deed. Bonnie had no knowledge of the prior conveyance to Caroline. Bonnie took over possession from Damon. The jurisdiction that they live in is the notice jurisdiction. After Damon left, Bonnie discovered the previous conveyance and brought an appropriate action against Caroline to quiet title to Creepy Mansion. If Bonnie wins, it will be because C, Damon's deed to Caroline was not in Bonnie's chain of title. And why is that the case? Because it's a notice jurisdiction. I think that is it for that. Question? All right. time to go through these future interest questions. Let's try to do a couple of them. I'd like to get them done. So we'll have to do foreclosure next week, or I'll see if I can record a video for it. On that note, a couple things. Number one, let me make a couple of announcements. So number one, there is a poly poll in Teams. If you can please take it and tell me officially what you would like me to do with your quiz 1 grade. Number two, I am going to change around the reading a little bit, and I will post in Teams about it. Basically, I had originally done the reading schedule as if we were going to be in person, and I was going to be at a conference one of those days. Well, I am not going to be at a conference, and we are not in person. So I'm going to move zoning up and then leave it so that the last 2 classes we can do review sessions for the exam. So if we do not get to foreclosures next week, we can get to foreclosures the Wednesday or Friday after, because we'll have 2 review sessions. All right, so quickly, number 16. Oh, by the way, that was a Vampire Diaries question. Okay, number 16, Dean to Sam for life. Then to Bobby's first child that reaches 22 and their heirs. Sam has no children. So we have Sam first gets a life estate, right? Then to Bobby's first child, so Bobby's child, to reach 22 and their heirs. So that would make it a fee, contingent remainder, right? And fee simple. So we know that's a contingent remainder, so we need to apply the rule against perpetuities. So we have all the lives in being are Dean, and Sam, and Bobby, right? So let's say that they go along and then we birth a child for Bobby. And then a year later, Dean, Sam, and Bobby die. This child is born in 2000. They die in 2001. And then we calculate the, so the first child to reach 22. So we take for B, so for the, first we calculate the wrap line, which is 21 plus 2001, which would make it 2022. Okay. And then the question is, does B's child, will they be 22? Well, let's make this not a year. Let's make this 6 months. Okay. Will they be 22? And the answer is no, they won't be 22 before the rule against perpetuities. They'll turn right after. So violates the rule against perpetuities. This is the same question that was on your quiz 1, by the way. And so because it violates the rule against perpetuities, we have to cross out then to Bobby's child. And so then we're left with Sam having a life estate, and then Dean getting a reversion. And Bobby gets nothing because he wasn't in the conveyance anyway. Next, Rosalie to Hank and his heirs, so long as it's used for a spice shop for the next 15 years. Then Adeline and her heirs. Okay, first of all, it's 15 years, so we know that we're not going to apply the rule against perpetuities. Okay, so we have Hank gets a fee simple subject to an executory limitation. And why is it an executory limitation? Because as so long as is the wording that is used. And then we have Adeline and her heirs that gets a shift shifting executory interest because shifting is for third parties, springing is for the grantor. And the grantor gets nothing because this is a fee simple. So this is a complete, that is the greatest amount that they can get. Okay, moving on. Try to quickly go through the rest of these. Marty to Wendy, so long as Reese lives. So that's a life estate per Ochervy. Then to Charlotte if she doesn't get married. Okay, so this is a contingent remainder. Come on. And fee simple. All right. And it doesn't violate the rule against perpetuities because Charlotte has to get married during her lifetime, right? So you can go through the timeline, but if we do that, if we look at Marty, Wendy, and Charlotte, they're the lives in being, we say that at any point Charlotte has to get married has to be before she dies. And so that condition will be fulfilled before she dies. And so that is why the rule against perpetuities doesn't apply. All right, moving on. All right, Matre to Richa for life. Then if Darren has any children, to Darren and the heirs of his body. Darren currently has no children. And here we have a life estate to Richa. And then it's a fee tail because whenever you see the words of heirs to somebody's body, then that is automatically a fee tail. The rule against perpetuities, again, doesn't apply because although we have a contingent remainder, so you'd want to check Marty, Richa, and Darren. So Darren is the one that needs to have children. Well, Darren has to have children before he dies. And so not violating the rule against perpetuities. There's no, they have to turn a certain amount of years or anything like that. So, all right. So if the condition, so rule of thumb, if the condition can be met within all the lives of being, then you automatically aren't going to have a problem with the rule against perpetuity. Okay. Nora and her heirs. But if Nathan becomes a programmer, then Ingrid may enter and terminate the estate. Nora gets fee simple subject to condition subsequent because the subsequent condition can come and divest her of her interest. Nathan gets nothing. He is just being used as a in the condition. And C, it is a right of entry because a right of entry goes with a fee simple subject condition subsequent. All right, that's it for the quiz. I will stay around for any questions, but we are technically done with the review session. Okay, seeing as there's no questions, adios. Have a great weekend, everybody.